Good morning, everyone, and welcome to today's Beasley Allen webinar, Class Actions, Whistleblower Claims in Your Practice. My name is David Byrne, and it's my pleasure to introduce our speakers for this important litigation topic. Today, my partners Larry Golston, Rebecca Gilliland, and Rachel Minder will discuss the case-building strategies and practices for winning complex consumer and government fraud claims. They'll address the differences between consumer class actions and whistleblower claims, and they'll describe for you how these cases are critical to holding businesses accountable for their harmful actions. Now, while we're waiting on the last of our registrants to join us, let's take just a few moments to go over some important CLE-related notes. First, today's webinar has been approved by the Alabama and Georgia State Bars for 1 hour of CLE credit. Now, in order to receive that full credit, you've got to stay on for the duration of today's program. A link to today's presentation was included in the Zoom confirmation email you should have received when you registered. But by the end of this week, you'll receive another email with a certificate of attendance and an evaluation form and an updated presentation and video link. You can email your completed evaluation form to webinars@beasleyallen.com. And we encourage all of you, please send in those evaluation forms as they're very helpful to us as we put together these programs. Now, today's webinar is being recorded. And for those Alabama and Georgia attorneys participating by phone, please email us your name, your phone number, and your state bar ID number. You can send that to webinars@beasleyallen.com. That'll help us ensure that each of you receives full CLE credit for today's seminar. For those of you practicing in other states besides Alabama and Georgia, we're going to send you a certificate of attendance that you can then pass along to your own state bar. Also, be sure to check out the events page of our website, beasleyallen.com/events, as we will be adding more live webinars throughout the year. For those of you who participated in our webinar program last year, you know our webinar presentations are a fantastic way for you to get an entire year's worth of CLE credit just by watching our monthly presentations. And this year, you can now access our on-demand webinars whenever you like, again, by accessing beasleyallen.com/events. That's beasleyallen.com/events. Finally, folks, if you have questions during today's webinar, we want to encourage you to use the question and answer feature that's located at the bottom of your screen. We're going to set aside time at the end of today's program to try and tackle the questions submitted by all of our viewers. So with that, Larry, Rebecca, Rachel, let's get started with today's program.
Sounds good. Thank you, David. I'm going to kick it off with just some basic, a really elementary view of class actions and what a class action is, how to get a class action certified, and how we, what our typical process is when we are investigating and filing a class action. So first of all, what is a class? It's an action that it's brought on behalf of one representative party on behalf of all people who have been harmed in the same manner by the defendant or defendants. So anyone with similar injury or financial harm that would be part of the class is represented by that lead plaintiff or the named plaintiff. So when you see a complaint that says John Smith on behalf of all others similarly situated, they're bringing that on behalf of the class, all of those who are similarly situated. It's the named plaintiff or the class representative who is undergoing that discovery on behalf of the class. They're typically deposed in a class action. They are the ones answering the discovery, monitoring the pleadings, checking facts that are filed with the court, and that. So that one person is taking on the role of representing hundreds or thousands of people in a class action. And it could be tens of thousands of people whose legal rights are affected by the suit or the allegations included therein. And it can be one or two people named in the complaint that are representing those thousands of people. In federal court, class actions are governed by Federal Rule of Civil Procedure 23, and that's where we find all of the rules and the governing aspects of how to get a class certified, basically. So when under 23, Rule 23, there's different types of classes that you can file and get certified. The first is a 23B1 class, which involves, it is a mandatory class, which means that individuals cannot opt out of the class action. It's the less common type of class action. We don't typically practice those in our section. It's not the best avenue for a consumer fraud class or the types of classes that we do, but it would involve situations where there's one common fund or a limited fund, not to be confused with the common fund that defendants often set up for a settlement of a class, but it involves that one common fund at the beginning that everybody has a claim to. And you know, if some people were to opt out and everybody else got money out of that common fund, it would leave none for the rest of the people. Or it involves lawsuits about rights. If you have a voting rights class and an inconsistent ruling among classes would cause issues, a 23B1 class would do away with those issues because everyone is in the class. You can't opt out and file a competing lawsuit. 23B2 class, of course, is where you have injunctive relief. The defendant's doing something that you want to ask the court to stop. A 23B2 class would then give you that or be the avenue for seeking that injunctive relief. And then a 23B3 class is what everybody typically thinks of when they think of a class action. That's where you get the monetary relief. It is an opt-out class. Not everyone is required to be part of the class. Notice is required to go out to the class members. So that's typically what people think of when they think of a 23B3 class. Not listed on this slide is a 23C4 class, which is where a court can certify a class for issues only. So when they think there's common issues, but maybe not enough common theories among the class members' damages or their injuries, they can certify it for that issues only class, 23C4 class. And so some of the discovery will proceed as a class. But again, those are not as common as a 23B3. And 23B1 is also not as common as a B3 or maybe even B2. And when you're trying to get a class certified, of course, when you file the complaint and you're doing the beginning workup on a case, it's not guaranteed to be a class action. You file it as a proposed class action, and you have to work that up to prove to the court why it should be a class action. Certification can occur after the plaintiff files a motion for class certification or a settlement. So sometimes the court doesn't certify the class yet, but you reach a settlement with the defendants on a class-wide basis so that you can then ask the court for approval of the class for a settlement purpose. So the beginning, it's a proposed class action. It's not definite that you'll get the class action status, but you proceed as much as you can with trying to prove up those common claims and establish your basis for filing the class. To get that class certification, there's certain elements or factors that you have to prove to establish your class can be certified. The first, obviously, is numerosity. There, you can't have a class of 2 or 3 people who could easily be joined in one lawsuit. There's no set minimum number by the Rule 23. Jurisdictions have different case law out there on what they typically certify. It doesn't have to be a certain number, but you have to show that the size of the class is so numerous that you cannot adequately or manageably join those into one action. So it could be a few dozen, could be hundreds, could be thousands. Obviously, the smaller number of people, the more difficult it is to certify. The next question is commonality. So there have to be common questions of law and fact as to all class members. This is also similar to the predominance of issues factor. The common questions have to predominate over any individualized issues. So, somebody may have a slight different amount of damages than another, but that's not enough of a defeat to the common question of, did the defendant do the same thing to both of us to defeat that predominance issue claim. Also, typicality, the proposed representative's claim has to be typical of the class. So whatever happens to your lead plaintiff, that has to be a similar situation than that happened to everyone else in the class. If your plaintiff has some specialized issue that probably didn't arise in the same way for all other class members, their claims may not be typical of the class, and they may not be the best representative for your class. And that goes to the adequacy claim. The proposed representative has to adequately represent the interests of the class. Also, class counsel has to adequately represent the interests of the class. So your class representative cannot go into a deposition and say, I'm really just here for me, and whatever happens with the rest of the people, we'll see. They want to be there because they want to hold the defendant accountable for whatever happened on a uniform basis to everyone in the class. The additional elements for certifying a class would be, Rebecca, you want to change the slide? Ascertainability, how are class members identified? Does the defendant have a log of everyone? So I do a lot of insurance class actions. The defendant obviously has for purchasing a product. We also do a lot of auto defect class actions, which Rebecca is going to talk about. And people have to show, I'm the owner of this car. How do we ascertain the members of the class? And then finally is predominance of damages. There has to be a common measure of damages that applies to all class members. So everybody doesn't have to have the exact same number of damages. So it's not that everyone was harmed $20, that's a class, but you have to have a common measure of damages. So is there a common fund, and people paid in, they paid different amounts because of the defendant's wrongful conduct, but we can give them each a pro rata share of what they paid in. Some way of giving everyone a fair amount of the damages that you can get in a class. So some common types of class actions would be consumer fraud, which we do a lot of in the fraud section. I know that seems a little obvious, but that we have a lot of those classes. Also misleading advertising or defective products. We also have a lot of those with our auto defect classes. Also, we have another class with the Fisher Price Rock and Play product. It's a defective product class. Employment can be a classable litigation, and that's not, one person has experienced a discriminatory workplace. It is everyone at this company was forced to work over 40 hours a week, but nobody was paid overtime. Situations like that are classable. It's hard to see on this slide because I obviously used the bad color for the background, but at the bottom it says things to look for. The pattern of practice by the defendant is number one. It has to be a uniform conduct by the defendant across the board. So a lot of companies that we investigate, they're doing crazy things, and there's a lot of people who are upset by what those companies are doing, but they're not doing the same thing to every single person, and those are hard things to class. Whatever the defendant's doing has to have that broad impact to hundreds or thousands of people that you can bring in one lawsuit. And then class-wide damages. Everyone has to have that one methodology to determine the damages for their injury. Finally, some potential pitfalls to look for when you're determining is this a classable case would be, first of all, arbitration clauses and class waivers. If the plaintiffs or the class representative have contracts with the defendant or any kind of paperwork where the defendant says, if you're using this product, you're subject to arbitration, or you waive your right to bring a class action, Well, obviously you can't bring a class action if you waive that right. Reliance issues is a big one. So fraud claims are very hard to get certified as a class because of that reliance element to a fraud claim. It's not impossible, but they're hard because proving a reliance is often an individualized issue. So that's the third potential pitfall, is the individualized fact. Is everyone harmed in a different way that would require too much individualized inquiry into their injury and their harm and what has happened to them? If so, it's probably not best for class treatment. And then finally is class waivers in statute. So for example, the Alabama Deceptive Trade Practices statute it includes in the statute that you cannot bring a class for that claim. So that's not in every state, it's not in every statute, but that's again something to look for. If you think you have a really great claim and you think you can bring it under this act, make sure that act doesn't waive those class actions. So that's all I have as just a primer in class actions and what we look for when we're investigating those. And I'm going to turn it over to Rebecca, who's going to give you a little bit more in-depth look at how we move that case, a class case, to trial.
Hi, everybody, and thanks, Rachel. So I don't have a whole lot of slides because I kind of just wanted to talk about the difference of how you might treat a case when you're taking it on an individual basis to trial, as you would compared with what we take as a class. Y'all have probably heard before, we did just take a class to trial in September out in the Northern District of California and received a jury verdict that comes out to about 102.6 million. So these are kind of some of the things that we noted along the way that are slightly different from a class and an individual perspective. One of them is just 30B6 depositions. Y'all know the BMS case that came out a couple of years ago from the Supreme Court. That kind of added an extra layer when you're dealing with an MDL or a multi-plaintiff case, whether or not you have to establish personal jurisdiction from every single plaintiff over that defendant. And the Supreme Court said in that case you did, but that was not a class action. So there's been a lot of litigation back and forth on the impact that BMS might have on class action litigations. And there's a couple of different splits on various different reasons. So if you're dealing with an FLSA case, for example, those are opt-in classes, and there's a few circuits that have said BMS does apply to that, because when a class member affirmatively opts in to join the class in a certain jurisdiction, that they then have to establish personal jurisdiction over the defendant for their own individual claim. So the 3rd, 6th, and 8th circuits have required opt-in FLSA classes for absent class members to establish personal jurisdiction. The first, even for FLSA classes, disagrees. You don't have, they say BMS basically is a non-impact. When it comes to more broader types of class actions like consumer protection class actions, the 6th and 7th circuits have said basically BMS does not apply. The 9th circuit, it's been described as a punt, and it is a little bit, but the hints in that punt are that the 9th Circuit is not going to apply BMS. There are kind of 3 different times when, and this is a big focus of the arguments in the trial courts, 3 different times when personal jurisdiction should be brought up that are specific to a class. So, normally when you file an individual case and you are in state or federal court, you're going to have a motion to dismiss on personal jurisdiction if it's, if you're not in the home state of that defendant. Well, when it comes to a class, it might not necessarily be an available defense at the time of filing, because some courts have said that until class certification, non-lead plaintiffs are not parties before the court. Because like Rachel mentioned, when you first file your class action complaint, it's a proposed class action. So there's back and forth on that and when it's going to apply. And that's essentially the track that the 9th Circuit took. They weren't going to rule broadly whether BMS applies or not, but kind of hinted it would not. But they did punt because the question at that point was waiver on the timing of that filing. So when I only mention that to kind of bear in mind that based on BMS, what we've been having to do in MDLs and multi-plaintiff complaints is try and establish through a 30b6 deposition personal jurisdiction over the defendant as to each plaintiff. So since it's not 100% clear, SCOTUS actually declined to address the circuit split twice, both from an FLSA case and a non-FLSA case. So because that hasn't been, the Supreme Court hasn't said BMS does or does not apply to class actions, that's something you just might want to bear in mind. Do I want to use a 30b6 deposition to make sure that I have asserted personal jurisdiction over non-resident class members? And then the bigger question that you have to deal with during discovery, but also impacts your trial strategy, is going to be depositions and things of current and former employees. So generally speaking, if you want to speak to, let's say you're dealing with an automobile manufacturer and you want to speak to someone who is not going to qualify as a corporate officer, director, board member, or something like that, whether they are a current or former employee, technically under the rules, you might need to subpoena them for a deposition. Most of the time, defense counsel is going to be more amenable because they want to arrange it and everything, and they might just agree to have them appear by a notice. But when it comes to trial, they might not. And then you might be faced with a witness that you were able to depose by agreement through a notice, but that he was technically an unavailable witness for trial. And if you can't compel their attendance to trial, then you might be able to use their prior deposition. So what that means is when you're getting ready to take your deposition, if there are, for example, documents that only this particular future unavailable witness can authenticate and lay the foundation for, you need to get that in your deposition. So don't make the mistake of assuming everybody you depose is going to be available at trial. They might not be. Unlike in an individual case where you're in state or federal court where the defendant is, those employees are probably also within the subpoena power of that court. But if you filed a class action in another state, in federal court, they might not be there. So just, it does kind of force you to prepare a little bit more in advance. You have to kind of start identifying not just your hot docs, but also literal potential exhibits well in advance, because you want to make sure that you've done all the legwork you need to do to get those actually admitted at trial. You don't want to even play your depo clip at trial and then not actually have those documents moved into evidence. So then the next thing that I want to talk about is discovery when it comes to experts. So there is a good bit of back and forth. There's a lot of variation on what experts are actually required. And I know Larry's going to talk about this a little bit when it comes specifically to QTAM cases, but when we're talking about a consumer protection case or a products liability class, an implied warranty class action or something like that, there's some back and forth about whether or not you need certain types of experts, we'll say. So one of the first things you have to do is figure out what type of expert opinion do I absolutely have to have? Is there something that is mandatory? For example, can I not certify my class if I don't have an opinion that says every class member suffered this harm? Is it enough to say let's use a vehicle class action. Is it enough to say every class vehicle suffers this defect? And there's the Ninth Circuit recently had a case up on appeal. It was Braverman versus BMW. And in that case, the Ninth Circuit, especially at the oral argument, was pretty clear that you do not have to have an expert say every class vehicle has this defect. And that was a very specific case. It was dealing with electric vehicles. But so right now, there's not a bright line rule that says you must have an expert say every vehicle, every class member has this defect. But to address the commonality aspects that Rachel discussed, through some form, you've got to have that. It might not necessarily be an expert. Maybe you need internal documents, you need testimony, whether deposition or live at trial, that says every vehicle has this defect. Therefore, every member of the class who own these vehicles suffered from that harm. You just might not need an expert. The other question is damages. Rachel mentioned you have to have a common calculation of damages, and you do, and that means a common methodology for calculating those damages. Most of the time, that's going to require an expert, but that also might not, strictly speaking, require an expert. For example, if you have testimony or documentation that, let's say the defendant had done some research and they determined what the cost of the repair was going to be, that could be a party opponent statement or a statement against interest, whether you actually get the live testimony or not, if it's in writing. And if that applies to all of the class vehicles, that might be your calculation of damages. That's certainly helpful to have an expert say, for example, repairing the vehicle is the calculation of damages, and then you have that statement from your defendant saying this is the amount of damages, but it might not, again, strictly speaking, be required. So when you're bringing your claims in a class, it's not just a matter of, do I need an expert to say this is damaged? Remember the Daubert requirements. If it's something that's beyond the normal reasoning of the average consumer, you probably need an expert to explain it. That might be something more simple, like let me explain to you how an engine operates, as opposed to let me explain to you that this is a defect. But it's going to depend a little bit on the jurisdiction where you're located. And then, just assess the specific needs of your case. Do you actually have to say it's defective, or can you just say all of them are the same? So jury selection is not completely different in trial case versus an individual. For example, let's use an auto defect case again. If you have an individual products liability case and you are going to poll the jury anyways, because you want to find out if any of the potential jurors own that vehicle, or if they have let's say they just love that manufacturer or they hate that manufacturer, you're probably going to ask those questions anyways. The twist to that is that in a class, they might be class members. So it's a little bit different from just let me figure out if they have a potential bias. They probably shouldn't be on the jury at all if they are a class member. So it's kind of taking the same questions, but they go one more step in the impact that it has on your actual jury. Opening statements, not drastically different again, but remember the key in a class action is, as Rachel described, your plaintiffs, your lead plaintiffs are representing a class of people. So generally, pattern jury instructions allow that in a class action, the jury may apply the testimony, the evidence, and the facts of that lead plaintiff to the remainder of the class. So that's probably something important that you want to remind the jury. You're going to hear testimony from certain individual representatives, but you are permitted under the law to take those facts and apply them to the class as a whole. And that, frankly, should go in opening and closing, because you want to remind the jury that these people are just representative. They're just examples. And then the key is, just like with any opening, describing not only what the defect is, if you're doing an auto defect, whatever the false advertisement is, if you're doing a different type of consumer protection claim, what makes it false and how it could be misunderstood by the average consumer. Witness concerns, I touched about this a little bit earlier. The biggest witness concern from my perspective is that subpoena question. You might have a defendant, like we did in our case, that was willing to bring technically unavailable witnesses to trial, and they represented to the court on the record that they would make them available. So, that comes down to a question of technically under the rules, are they unavailable because they've been offered to be brought? And, ultimately in our case, they came live. So it was moot. If they're present in court the day that they are supposed to testify, you're not going to be able to use your deposition clips, but you do have the opportunity to take them live. So, you want to make sure that your deposition covers all the documents and things that you need to get in just in case, because you won't know until trial whether or not they are going to voluntarily show up. And then the role of experts, we discussed this a little bit. Obviously, pay close attention to any Daubert rulings that you have one way or the other. You want to make sure that your opinions are restricted if the court restricts them at all, but also pay attention to the very often nuanced limitations that courts will put. If your expert has 10 opinions and the court excludes 2, get in the other 8. You don't have to just get in 4. you have 8 that are allowed to be entered that when the expert drafted the report were considered important enough to be opinions in your litigation. Just make sure you get them all in. So pay attention to those nuances. But again, the real question is, in your jurisdiction, do you have to have an expert opinion on X? And if you have to have that expert opinion, that has to get in. And then closing, again, similar to opening, focus on those jury instructions, remind the jury that they are allowed to apply the facts of the lead plaintiffs to the rest of the class. Because that's something that I think is a little bit more difficult for the jury to wrap their head around. They're not just deciding the 1, 2, 3, 4 people that are in front of them and testifying. They are deciding the impact on everyone. So when they get to their verdict form, typically it's going to ask, did the plaintiff in the class prove X on behalf of themselves and the class? So you need to, the last thing that you need to remind the jury is that you are deciding this on a class. These people are here on a representative capacity. You are perfectly allowed and should apply the facts that you hear from these witnesses, from these plaintiffs, to the class as a whole. And I think that's kind of one of the more important sort of themes, to just remind the jury that this is a class. And this is just a little bit of information about the recent jury trial that we had in September. This case dealt with the piston rings wearing on some of GM's V8 engines. It's a 5300 5.3 liter V8 engine, and the piston rings were wearing. So we had testimony from our representative plaintiffs about their experiences with the vehicle and the different kind of problems that they had encountered because of this defect. So the case was brought in we had a consumer protection claim, and then we had 2 state classes for the implied warranty claim. So, you know, again, one of the first things you do when you're preparing is go look at those jury instructions. What do I have to demonstrate? And the jury was with us. They remembered this was a class action. So we were awarded everything that we had asked. That was $2,700 per class member. And that comes out to about $102.6 million. We are currently waiting on the judge to rule on some of the post-trial motions. So, you know, the directed verdict and then a motion to decertify the class. And there's no timeline on those. Our judge, Judge Chen, he's phenomenal in the Northern District of California, but he was going immediately into something like 12 weeks of trials after we had our hearing on these motions. So we don't know exactly when we'll get a ruling, but we do expect it to be favorable. We've satisfied all of the elements, had the necessary expert testimony. So we're expecting to maintain that verdict, and then we'll see if GM decides to appeal it or not. With that, I'm going to hand it over to Larry, and he's going to talk about our whistleblower litigation practice.
Thank you, Rebecca. Yeah, I'm going to talk briefly about the False Claims Act. We have a robust whistleblower practice, but the False Claims Act is actually America's first whistleblower law, and it is in my opinion, the most powerful whistleblower statute / anti-fraud statute that we have in America. And I spend a good deal of my practice practicing in this area. And so as a brief overview of the False Claims Act, you know, what is it? It is a statute that was enacted back in 1863 by President Abraham Lincoln. And the reason it was enacted was because at that time, during the height of the Civil War, the federal government began noticing that it was being provided substandard goods and services related to the war effort. And so to combat the fraud and target the fraud that was being committed, the birth of the False Claims Act came into being. The statute has about 7 primary different causes of action. However, the most litigated aspects of the statute are the ones I have here on your screen under section 3729A1A, which is knowingly presenting a false or fraudulent claim for payment, and that could be presenting it or causing someone else to present it. A1B, knowingly making or using a false record or statement that's material to a false claim. The A1C claim is typically known as a conspiracy count, where you allege that the defendants have conspired to violate the False Claims Act. And then you have what's called an A1G claim, which is commonly referred to as your reverse False Claims Act claim. And that simply is a claim where the plaintiff or the whistleblower is alleging that false records or statements were material to an obligation to pay government some money were created, or false records or statements were used to conceal an obligation to return or pay money back to the government. Those are your four most commonly litigated areas of the statute. And then in recent times, and I say recent, in the last, I would say 15 years or so, you do see a rise in anti-kickback litigation. During the Obama administration, the False Claims Act was amended to make it express that an anti-kickback violation, or I should say a violation of the anti-kickback statute, is also a automatic violation of the False Claims Act. And then, of course, you have your anti-retaliation provisions of the statute that allow a whistleblower to recover if they're retaliated against for coming forward. So the crux of the statute is that it allows private citizens to come forward and bring the claims under the False Claims Act that I've just mentioned on behalf of the government, which is what the Latin phrase qui tam means. And the government, once the lawsuit is filed, it has to be filed under seal. The government may, at that point in time, intervene or decline to intervene. In practice, what the government is going to do is exercise its rights to investigate the case while it's under seal. And those investigations can vary, for months. I've had cases where I have cases right now where the case has been investigated and it's been several years while the case has been under seal. The statute says they have 60 days, but that's just kind of, the formal requirement. What inevitably happens is that the government will come back and ask the relator or relators counsel, how much, can we get an extension on the time to investigate? And as the attorney for the whistleblower, you're going to most likely always give them that time because you want the government to intervene. And I used that term a minute ago. The whistleblower is known as the relator in a False Claims Act case, and as their lawyer, you're known as the relator's counsel. You look at the share that the relators could get. So if the government intervenes, the relator can get anywhere between 15 to 25% of what the government recovers. If the government declines to intervene, the relator can get 25 to 30%. And so you may think, well, Golston, you just said a moment ago, you want the government to intervene, but it looks like if the government declines to intervene, we will get more of a reward. And while that's true, the statistics bear out that 98% of False Claims Act cases that are intervened in by the government result in some form of recovery, either through a jury verdict or through settlement. Whereas on the flip side, if the government declines to intervene, most cases, I would say only about 5% of the cases survive the motion to dismiss or end up going forward and get any type of monetary reward. That is because these cases are very complex. You have a very high pleading requirement under Rule 9B of the Federal Rules of Civil Procedure to plead the fraud with particularity. And even if you can get across that hurdle, the problem that you run into is, A, can you finance this litigation for 2, 3, 4 years? Because that's how long sometimes it takes to get to trial. And do you have the wherewithal, as Rebecca was talking about a moment ago, to have the necessary experts that you're going to need to successfully litigate the case? And I'll talk about experts and trial a little bit later. The penalties include the penalties that you can receive. This is why the statute is so powerful. Not only do the government is entitled to get back all of the money that it lost as a result of the fraud, but it gets interest on that money. It gets a civil penalty for every false claim or record that was committed in the case in the form of conspiracy. Every act in furtherance conspiracy is also penalized, and that aggregates very, very fast. As of January 30th of this year, your lowest civil monetary penalty is $13,508, and the maximum is $27,018. I've had cases where the civil penalties alone not only are in the 8-figure range, but can get close to 9 figures just off of the penalties. And the government also gets to treble its damages in the amount of money that it was defrauded. Plus, the Relators Council gets its attorney's fees, costs, and expenses. So you can see, if you just do the math real quickly, a case worth about $3 million in fraud to the government could exponentially mushroom into a much, much larger case. Next slide. So the common question I'm asked most often when I tell people I do whistleblower or False Claims Act litigation is, okay, what is that? What kind of cases, do you actually end up litigating, and how do you get the cases? So these next couple of slides are going to deal with the first question. What are the theories of liability? And these are the common theories. You have fraudulent billing for Medicare and healthcare treatment, because while any fraud against the government, with the exception of tax fraud, can be brought under the False Claims Act, there are primarily two major players that you see a lot. Those are healthcare organizations. That's where you see a lot of fraud in the healthcare industry. You see a lot of fraud in the military, homeland security area. And you're beginning to see a lot more fraud in these other two areas I'm about to mention, which are scientific research and cybersecurity. You're seeing a lot more fraud against the government in those areas, as well as in general procurement fraud, no matter what kind of government contracting is involved. With respect to fraudulent billing and Medicare, there's some sub components of claims you see. One of the first ones is claims for services not actually performed, which is kind of self-explanatory. That's where you'll have a medical provider bill Medicare, TRICARE, or Medicaid for services that it never performed. Services not medically necessary. Likewise, if you had any experience with Medicare or Medicaid, CMS, the Center for Medicare Services, requires that as a requirement or a condition of reimbursement, the medical services or devices provided have to be reasonable and medically necessary. So, and basically that boils down to whether or not the services provided, the drug, the medical device, were reasonably safe and effective. And if you have situations where you can go in and establish that, hey, this doctor provided a person with medication or services that the person didn't need, you can establish a not medically necessary claim. Other type of claims are claims for misrepresenting the provider of services. If you ever dealt with the medical profession, you know that the medical profession, doctors, nurses, CNAs, they all are provided with provider identification numbers or PIN numbers. And a lot of times in this area of fraud, what you have is you have a nurse may perform a certain procedure on a patient. You may even have a nurse practitioner perform a procedure on a patient, but then the healthcare organization will bill that service under the doctor's PIN, or they will bill the services under the nurse practitioner's PIN when a LPN actually did the services. So that type of fraud is commonly litigated. Upcoding for services that are goods is a similar type of fraud. That's where, when you're billing Medicare or any private insurance company for that matter, the hospital or the doctor's offices bill according to certain pre-described health codes. And what happens a lot of times is, to maximize their profits, these doctors' offices and these hospitals will bill for a code that they know pays substantially more in reimbursement funds than the services that were actually provided. That's called upcoding. And that's another common area of fraud that we see. Unbundling services. So some services are performed in such a manner that they're all bundled together for one code and billed as under one code. You see that a lot of time in lab tests, where there may be, 6 or 7 different tests performed when blood or urine is sent to the lab, but those 6 or 7 tests will be bundled under one diagnostic test, and will be billed to Medicare accordingly. And what happens is that type of fraud routinely involves where the doctor's office or the hospital bills the bundled code, and then they will go back in and bill 3 or 4 or 2 or 3 components of that bundled service separately as if it was a standalone service. That is also fraudulent and something that's commonly litigated. And then that's under the unbundling services theory. And then false cost reports every year, whether they're on a fiscal year or otherwise, hospitals have to submit cost reports to Medicare if they are a hospital that receives Medicare funding. And that's because Medicare funds a good amount of the capital costs for equipment that these hospitals provide to their patients. And you see a lot of fraud in those annual cost reports because hospitals will inflate the cost of what their capital costs really are. Next, another theory is the Stark Act. So the Stark Act is basically what's known as the self-referral statute, and it is unlawful under the Stark Act for a physician to that is being reimbursed under Medicare or Medicare to provide a service to a patient where that physician has a financial relationship involved. So a common situation where you have a self-referral or a financial relationship that's involved is where you have a doctor, let's say they have a primary care or a general practice, and that doctor also owns a X-ray lab or a lab that provides oxygen supply devices. And then what happens is a patient comes in the doctor's office, is treated by the doctor, and then the doctor will routinely require that that patient go and be seen by another company to do lab diagnostic work or to go buy oxygen-related equipment, and never discloses to the patient that, oh, I have a financial relationship with the company that I'm referring you to. That type of self-referral violates the Stark Act, and in turn, by statute, violates the False Claims Act. The anti-kickback statute that I mentioned earlier, the anti-kickback statute is a standalone statute that makes it unlawful and actually makes it a crime for anyone to receive remuneration in exchange for referrals of federal health care services. That referral can be as simple as the doctor being hired and paid a rate or a salary that's clearly outside of the normal rate of salary. And the referral, what makes the referral unlawful is can be anything of value. The remuneration can be anything of value. It is a very powerful weapon in and of itself, but when you combine it with the False Claims Act, the statute, after it was amended, basically says that any kickback offered for federal healthcare services automatically violates the False Claims Act. So when a doctor who, let's say, receives gifts and vacations from a medical pharmaceutical company, and they, in exchange, prescribe that pharmaceutical company's drugs to their patients, that would violate the anti-kickback statute. And every claim that that doctor bills to or bills for reimbursement to Medicare is deemed tainted and unlawful, and you have a violation. That is true even if the medication that was prescribed is actually effective for that patient's condition. It doesn't matter. Because of the anti-kickback violation, the entire claim is tainted and violates the FCA. Other types of claims are best value cases. That's simply kind of interrelated with cost reports. Hospitals get reimbursed for capital medical equipment, such as MRI scanners, CT scanners, ultrasound equipment. And under the Federal Acquisition Regulations, the FAR, there are prescribed certain ways that those hospitals or doctors' offices have to go about buying that equipment. And one way is through the best value approach. And under a best value calculation, price is considered, but you have to look at other extraneous factors to determine whether this equipment would be the best value for the services being offered by that physician to the patient. Off-label drug marketing. That's another common area that we've recently seen on the rise. Every pharmaceutical company or medical device company has to have their drug or device approved by the FDA. And when the FDA approves a drug, they routinely approve that drug for a certain indication. And what happens is the pharmaceutical companies, when the drug is about to come and become a generic, they realize they have to figure out a way to make more money off of that drug. And one of the ways they do it is they go and start having their sales reps pressure doctors into prescribing a drug for indications that it has not been approved for by the FDA. We investigated and had a case once where a manufacturer of a psychotropic drug that was approved for schizophrenia was being sold off-label and marketed off-label by a drug company. And they were telling the doctors that, oh, you can also use this to treat patients that are bipolar or depressed or have anxiety. And none of those indications were indications that the FDA had approved the drug for. Next slide. Defense and Homeland Security contracts. I'm going to run through these. Product substitution. Had a case where the government, the Army, was actually asking for a particular type of equipment to be used on aircraft, and the government contractor was using a different product in helping to make the wings on the plane. They were using a different product that was prescribed in the contract. So that would be product substitution. They had the products that were being manufactured for private airlines, but the government wanted a different type of equipment used on its wings. And what this company did is just took the wings that were being used for private airlines and gave them to the government. Mischarging and cross-charging. You see that a lot in Homeland Security and defense contracts. Cross-charging is simply where they have equipment and supplies being used on one contract, and they charge the government on a separate contract for all that equipment and material when the material and equipment wasn't being used on the contract at hand. And mischarging is where they literally just inflate the cost of the materials and equipment that are being used on a given contract. Failure to test or inspect is very similar. I had a key TAM case where, without divulging too much, the company was a contractor for government security. They were supposed to be making bulletproof doors, bulletproof windows. And a part of the contract with the government was you had to test the manufactured door and window seals once they were manufactured to make sure they were indeed bulletproof. And this company was skipping that process and just shipping them out without having been tested. Substandard products or services and failure to adhere to specifications, kind of self-explanatory. General procurement. We actually are in the midst of winding up a case that we tried in the Northern District of Alabama that involved with general procurement. And essentially, each type of procurement has a federal acquisition regulation that tells you the kind of procurement procedures you have to go through. In the case that I'm referring to, we sued the Birmingham-Jefferson County Transit Authority because they enter into a procurement with engineers and architects for some services and didn't follow the required statutory and regulatory processes for that procurement. And so that ends up being a fraudulent act. And then you have violation of the Truth in Negotiation Act, or TINA. There are some contracts that require that cost information and pricing data be negotiated if the contract is worth a certain dollar value. And a lot of times you will find out that government contractors are skipping this step, and that violates the False Claims Act. And then scientific research. Scientific research, you see a lot of hospitals and other institutions that get grants from the government, and those grants have stipulations that certain requirements are to be met, and these institutions of higher education and hospitals are just skipping those steps, and those end up being False Claims Act. Last slide, please. And so people ask, like I say, how do you get these cases? The statute says any person can be a relator, but the most common way you see cases are through employment cases, people who are employees, who are either about to be terminated or have been terminated, they feel the freedom at that point to come forward and tell about government fraud, because most times while they're working for the company, they're afraid to lose their job if they come forward. And again, there is an anti-retaliation provision if they do get terminated or harassed because of that. Contractors, a lot of times I have a case right now from a former military contractor who worked over in Iraq during the Gulf War. You will have a lot of times contractors will come forward, and then just agents in general. You have, accounting firms, people who are with the accountants, as far as their assistants. You have all kinds of different agents of different organizations and institutions that interact with the government, and they will come forward as well. So that's how you mine these cases by, looking at them, the disgruntled employee, the person who was a former contractor who is now, looking for work and is frustrated about losing that former contract. That's how you usually and typically get these cases. And as a note, sometimes people come to me and I have a state agency. State agencies, public universities, public hospitals, they cannot be False Claims Act whistleblowers by definition of the statute. And the last thing I'll point on is Rebecca brought up the trial of these cases. There are very few people in the country, especially in our state, that do False Claims Act litigation. There are even fewer who take these cases from pre-suit investigation all the way to trial. I have done that, and I'll tell you, experts, you're going to need sometimes a variety of experts. Mostly, you're going to need damages experts, because a lot of times you can't prove the true value of or amount of all the fraud that has been committed, and you're going to need an expert to come in and do statistical sampling. Federal courts are more inclined to allow experts to do that and do statistical sampling on damages as opposed to liability. And you're going to need those kinds of experts most often in these cases. And you have to find them early and often with a mind towards maybe having to go to trial in the case. So that's all I have.
All right, fantastic. On behalf of all our viewers, I want to thank Rachel, Rebecca, and Larry for bringing us a very thoughtful and thorough presentation. Always enjoy hearing from my Beasley Allen partners, particularly when they're discussing litigation topics that are really, really interesting like these. And we've gotten a few questions in from viewers, but before we get into that, I've got a few questions of my own, if you don't mind, and I'll sort of take this in reverse order according to speakers. So Larry, when we're talking about False Claims Act cases, and this is a two-part question. First, when the government chooses not to intervene and you proceed to trial, are you trying that FCA case to a jury, or is that a bench trial?
Good question. It's to a jury. It's just like normal litigation. If the government declines to intervene, you will try to a jury, provided you have asked for a jury trial on your complaint. And in federal court, it's usually going to be 9 or 6 jurors. Okay.
Is the jury made aware of the government's decision to not intervene in the case? In other words, does your defendant corporation get an opportunity to put that little jab in there that, hey, the government passed on this case?
First thing out of their mouth is they're going to try to diminish your ability to recover by saying, oh, the government didn't intervene in this case, and if they thought this was any case worth of value, they would beat it. And how we have countered that, I'll tell you a quick funny story. So at the trial we had up in Northern District of Alabama, up in Birmingham, defense lawyer stood up in his opening statement and said, "Where's the government? Where is the government?" He waved his hand, and on cue, I stood up and our whole litigation team stood up, because the statute clearly says we bring this claim on behalf of the government, and you have to fight for it. But I've been successful in several trials to get the judge to tell the jury in instructions before the trial starts that the relators counsel are here on behalf of the government.
Okay. Rebecca, quick question. I know you've done a lot of work in California over the years, and in California state court actions that involve complex civil claims, is there some different set of discovery rules that apply to those type cases as opposed to ordinary, maybe not so complex California civil cases?
So The real question is the judge's particular requirements. The California has its own set of civil rules of procedure, just like every state does, but those are going to be procedural. So when you're in federal court, those aren't the ones that apply. So, but interestingly, and this might be where you're going, California actually has a kind of a state version of an MDL. So you can have a consolidated case in California state court that operates almost identically as a federal MDL. There's a few more different options in California than there are in other states. Classes exist under state law and federal law. Rachel mentioned the Consumer Protection Act class waivers and things like that. So there are some distinctions depending on where you're going to file, but the discovery rules are not drastically different.
Okay. We've gotten a lot of questions in at the very last minute. So, and I apologize. I know we're running over time, but I'm going to try to hit on just a few of those before we close. The first question comes from Sean. He asked, what's the latest on government unilaterally dismissing a whistleblower case over the objection of the plaintiff? Larry, do you want to try that one?
Yeah, so the government has a right by the statute to come in. That's been some recent litigation, as the questioner is probably aware of. The courts have given the government more authority to come in and unilaterally say we want to dismiss the case. The current state of law is this. Practically speaking, if the government comes in and says, hey, we want to dismiss the claim, regardless of what the plaintiff's counsel say, it's going to likely get dismissed because the federal court judge is going to see you have a huge problem in proving materiality of that.
Okay. Again, we've gotten in a lot of questions here at the last. Got a question from Cynthia. She asked, how do we help the DOJ and the U.S. attorneys when they do intervene and file a complaint against the bad guys?
Good question too. So what we do in a lot of cases that the government has intervened in, we have a lot they don't intervene in, but we have a lot that they do too. And what you do is you continue to help investigate the case. You can't overstep their boundaries. Obviously, they have their own investigators. And a lot of times you're going to brief. So there's a lot of briefing going on. The defendants are going to file motion to dismiss, motion to exclude, discovery motions. You're going to show up to every deposition. You're going to file a responsive briefs on behalf of your client when any motions or challenges are raised. And you're going to aid the DOJ by essentially helping them find witnesses to prove the fraud that your clients brought forward.
Okay. Well, that's all the time we have for today, guys. I'm so sorry we ran a little over. For those of you watching, again, I would encourage you with our upcoming webinars, get those questions in as soon as they come to you, because we want to make sure we cover all of them throughout the course of the presentation. I apologize to those of you who we were not able to get to. Again, if you missed our earlier announcements, by the end of this week, you'll receive an email with a certificate of attendance, an evaluation form, and an updated presentation and video link. Please send your evaluation forms to webinars@beasleyallen.com. Again, for those Alabama and Georgia attorneys participating by phone, please email us your name, phone number, and state bar ID number to webinars@beasleyallen.com. Check out our events page for upcoming webinars. You can always access our on-demand webinars anytime you like at that same address, beasleyallen.com/event. Hey, if we weren't able to get to your question today, call our presenters. They'll be happy to answer your questions. You can reach them anytime at our main office line. Thank you for joining us today, and thanks as always for supporting our Beasley Allen webinar series. Have a great day.